Hello all. This is the third video on media law. As there are many topics which are not repeatedly came in the exams, I have to make three videos. Let us jump into the videos and topics. Central Information Commission. Introduction. Section 12 of the Right to Information Act 2005 deals with the constitution of statutory body known as Central Information Commission. According to this provision, the central government shall constitute a body called Central Information Commission by passing a notification in the official gazette. The Government of India, through the Parliament of India, amended the Right to Information Act in July 2009 and introduced some changes in RTI rules related to salaries, allowances, and tenures of the information commissioners. Salient features of the Section 12 of the RTI Act. The Section 12 of the RTI Act 2005 is termed as the Constitution of the Central Information Commission. The salient features of this section are as follows. Section 12, Clause 1 says this subsection empowers the central government to constitute a body known as Central Information Commission. Section 12, Clause 2, here it is called subsection 2. The Central Information Commission should consist of the Chief Information Commissioner and such other Chief Information Commissioners, not more than 10 as may be deemed necessary. Section 12, subsection 3, the Chief Information Commissioner and other information commissioners shall be appointed by the President of Republic of India on the recommendation of a committee consisting of Prime Minister of India as a chairperson of the committee, the leader of the single largest group in opposition of the Government of India in Lok Sabha. The Union Cabinet member shall be nominated by the Prime Minister of the India. Section 12, subsection 5 says the Chief Information Commissioner and other information commissioners should be the person of acknowledged superiority in public life and possesses wide knowledge and experience in the field of law, technology, social science, management, science, mass media, journalism, governance, and administration. Section 12, subsection 6 says the Chief Information Commissioner and other information commissioners shall not hold any office of profit or should not be a member of the parliament or shall not be a member of any state or union territory legislative assembly or shall not be pursuing any profession or carrying any business or shall not be connected with any political party. Functions of the Information Commissions. Section 18 of the Right to Information Act 2005 talks about the powers and functions of the Information Commission. As per this provision, it is the duty of Central Information Commission and the State Information Commission to inquire the complaints received from any person who has been unable to submit a request for information to a public information officer either at central or state level, either by the reason that no such officers have been appointed under this statute or the appointed officers refuse to accept his or her application. Sometimes as short notes you will get PIO, that is Public Information Officer, and who has been refused to get access to the information requested under this statute. Who here is person. The person has not been receiving any response for the application or he or she made for information and access to information who with the limited time as per this legislation. The person has been required to pay an unreasonable amount of fee and the person believes that the information provided by the officers are false, misleading and incomplete in nature in respect of the other matters related to the violation of the provisions of this Act. Coming to powers of the Central Commission. The Central Information Commission and the State Information Commission have the same powers as of a civil court while intimating a suit under Civil Procedure Code 1908, like to summon the attendance of any person or compel any person to give written or oral pieces of evidence on oath and or order him to produce documents or things, require the discovery and inspection of any documents, receive pieces of evidence or affidavit, requisition any public record or copies of documents from any court or office, issue summons for examination of documents and witnesses, any other matter related to this act. Coming to the next topic, sedition in India. What is sedition? Let us see introduction. The Constitution of India 1915 grants us certain fundamental rights which represent our basic human rights and liberties with which all of us entitled to. One of these rights is the right to freedom of speech and expression granted by Article 19, Clause 1A. This right isn't absolute though, and certain reasonable restrictions can be put on it in specific situations such as prevention of defamation of another person, maintenance of public order and decency, protection of integrity of the nation, etc., which are mentioned in Article 19, Clause 2. One of the cases where the right to freedom of speech and expression can be restricted in the case of sedition. What is sedition? Sedition refers to overt actions, gestures, or speech by a person in oral or written form which expresses his or her discontent. It's not dishonest, it's discontent against the established government in the state with the aim to incite violence or hatred against it. The sedition is classified as a crime in India since 1870. It has been defined under Section 124A, Chapter 4 of Indian Penal Code 1860. Activities are considered, which are the activities considered as seditious? Going by the interpretation of sedition by Indian courts, the following are some examples of activities that are considered seditious in nature. A group of people raising slogans against the government of India. A speech made by a person that clearly incites violence or public disorder. Written work like a newspaper article which incites violence or public disorder. Punishment for sedition. As given under Section 124A of IPC, the person convicted of sedition is punishable with either imprisonment ranging from 3 years to lifetime, a fine, or both. Sedition is a cognitive offense, which means the police can arrest a person accused of sedition without needing a warrant for the same. Sedition is a non-bailable offense, which means a person arrested for sedition cannot be released on bail by the police as a matter of his right. He has to apply for bail before a court or as a magistrate. Sedition is a non-compoundable offense, which means it cannot be settled with a compromise between the accused and the victim. Origin of sedition in India. In 1870, Section 124A was added into Chapter 4 of IPC, which deals with offences against the state. This was done as a response to the rising radical Wahhabi movement led by Syed Ahmad Barelvi. Some of the most famous sedition cases during the British Raj involved charges against the leaders of Indian independence movement. The first among them was the trial of Joginder Chandra Bose in 1891. After independence, the Constitution First Amendment Act 1951 added the term public order to Article 19, Clause 2, which meant that citizens' freedom of speech and expression could be put under legislative restrictions to maintain public order and stability too. Thus, the sedition was recognized as a crime, though the then Prime Minister Jawaharlal Nehru was of the opinion that anti-sedition law held no place in free India. Coming to case laws, cases of sedition before independence. These are famous cases before independence. Queen Empress versus Jogendra Chandra Bose and others. The facts of the case are, in this case, Jogendra Chandra Bose was accused of inciting rebellion through an article he had written in his own Bengali magazine named Bangobasi. In this article, he has criticized the Age of the Consent Act 1891, which raised the legal age for sexual intercourse for women from 10 to 12 years. Judgment given. While the act itself was perhaps a boon for Indian society and was supported by reformers and women's rights groups, the question here was of sedition and inciting violence against the government. Another case is Queen Empress versus Bal Gangadhar Tilak 1897. This was the first case in which Section 124A was defined and applied. In this case, the advocate and prominent freedom fighter Bal Gangadhar Tilak was charged with sedition. He spoke against Indian Civil Services officer Mr. Rand, who was the plague commissioner in Pune. His revolutionary speeches about the control methods of the plague encouraged other individuals to spread violence against the British, which ended with the death of two British officers. The judgment is given that the court said that no man should excite or attempt to excite this kind of disaffection. He should not make or attempt to make anyone feel any kind of enmity towards the government. With this in mind, the court convicted the freedom fighter of the crime of sedition and sentenced him to 18 months of rigorous imprisonment. The another case, famous case regarding sedition after independence is Kedarnath Singh versus State of Bihar, 1962. For the first time, the apex court addressed the issue of legality of this colonial era law in this case. Facts. In this case, the appellant was charged with sedition for certain speeches that he had delivered. In these speeches, he called officials of the CID as dogs and members of the government, Congress gundas, whose election was a mistake by the people. He was convicted under Section 124A by a magistrate court in the state of Bihar. He appealed to the Patna High Court, but his conviction was sustained. He then obtained special leave to appeal to the Supreme Court. Supreme Court said that sedition has been ruled as a crime to prevent the subversion of the government by inciting contempt or hatred towards it, which can rock the very stability of the society. It, however, clarified that a citizen is allowed to criticize the government so long as he does not intend to cause public order or violence. Coming to the last topic, visual and non-visual media on society. It is dealt under sections under the headings Introduction, Impact of Visual and Non-Visual Media on Society, and Legality of Visual and Non-Visual Media, and Conclusion. Coming to introduction, visual and non-visual media are two primary types of media used in modern communication. Both types of media are essential to various fields such as advertising, education, entertainment, and news. Visual media refers to any type of media that utilizes images, videos, and graphics to convey information. Non-visual media focuses on text, audio, and other types of sensory inputs. Visual media. The visual media includes everything from traditional print advertisements and billboards to digital platforms such as social media, online videos, and websites. This type of media utilizes the visual senses to deliver messages or information to the audience. Examples of visual media include movies, television shows, photographs, charts, and graphs, among others. Visual media relies on the eyes and the perception of color, shape, size to convey information. The primary advantages of visual media is that it is easily understandable and engaging. The use of colors, images, and videos in visual media make it easier to grab the attention of the audience. Another advantage of visual media is its ability to convey complex information in a simple and understandable way. Infographics and charts are excellent examples of visual media that can communicate data and statistics effectively. Visual media is highly effective in capturing attention, conveying complex information, and sharing on digital platforms. Non-visual media. Non-visual media refers to any form of media that does not rely on visual stimulation. This type of media utilizes sounds, touch, taste, and smell to deliver information or messages to the audience. Non-visual media often includes audio, podcasts, music, audiobooks, and sound effects. Text-based media such as books, newspapers, and magazines also fall under this category. Non-visual media relies on other senses such as hearing, touch, taste to deliver messages. Non-visual media is highly effective in conveying emotional and personal messages. Audio-based media such as music and podcasts can connect with an audience on a deeper level, often eliciting an emotional response. Audiobooks and storytelling podcasts can transport the audience to different worlds and create an immersive experience. Impact of visual and non-visual media in society. The visual media has the ability to capture the viewer's attention and engage them in a way that non-visual media cannot. The use of color, light, and shadow can also influence the viewer's mood and emotions. Excessive exposure to visual media, especially if the content is violent or graphic can have negative effects on mental health. Research has shown that exposure to violent media can lead to increased aggression, desensitization to violence, and reduced empathy towards others. In addition, the excessive exposure to social media can lead to social isolation, depression, and anxiety. Non-visual media, on the other hand, refers to forms of media that do not rely on sight, such as radio, music, podcasts, and literature. Non-visual media can have different but equally powerful impact. The legality of visual and non-visual media. The legality of visual and non-visual media varies depending on the type of media and the jurisdiction in which it is produced and consumed. In most countries, there are laws and regulations governing the production, distribution, and consumption of various types of media. Visual media, such as films and television shows, are typically subject to censorship and rating systems to ensure that they are considered they are appropriate for certain age groups and do not contain content that is considered harmful or offensive. Non-visual media, such as music and literature, are typically subject to freedom of expression laws, which protect the right of individuals to create and consume a wide variety of content. However, there may still be restrictions on certain types of content, such as hate speech or incitement to violence. Thank you. This ends all the topics on media law. Please like, share, subscribe, and comment.